Adesso siamo i più bravi dei più bravi. Quello è la ricompensa. Il microphone is not there. Dunque, siamo i più bravi dei bravi. Non facciamo della volgarizzazione, facciamo come un gruppo ristretto. Per parlare di queste sfide dell'intelligenza artificiale, continuiamo e affrontiamo il campo del diritto e lo facciamo con Paul Nemitz, che mi ha detto che è un giovane pensionato, però ha avuto molte responsabilità, in particolare alla Commissione europea come consigliere principale presso la Direzione Generale della Giustizia e Consumatori della Commissione europea e anche è stata in precedenza direttore responsabile per i diritti fondamentali e la cittadinanza dell'Unione. Ha svolto più incarichi in seno della Commissione europea su temi che sono vicini al nostro tema. Anche ha una vasta esperienza come agente della Commissione in contenziosi dinanzi alle Corti europee e ha pubblicato numerose pubblicazioni sul diritto dell'Unione Europea. Dunque vi lascio la parola sul tema AI and the law as a tool for the common good. Thank you.
Thank you. Thank you very much for the kind invitation, and I'm happy to speak to the few selected future leaders of faith in this world. I will try to encourage you to engage in democracy for the common good. So we have to speak a little bit about democracy, we speak about politics and the law. And let me say that modern societies are characterized by a great diversity of views about what constitutes the common good, the public interest. Such diversity is the basic tenet of freedom and liberty within the bounds of the constitutions. And these constitutions include the rights to freedom and diversity, including the diversity of religion. The trinity of rule of law, fundamental rights, and democratic decision-making traditionally serves to secure this diversity and freedom via a multitude of checks and balances and principles of division of power. The law, adopted in democratic processes, has the function to secure spaces for freedom and diversity and to establish the rights and obligations of people in their relations with each other, that's private law, and with the state, that's public law. In a society under the trinitas of democracy, fundamental rights, and the rule of law, everybody is free to act and make contributions individually and collectively to the public good according to a value orientation which may stem from a variety of sources, including religious orientations, but also, of course, pure commercial self-interest. So there's a broad scope of what motivates participation in democratic decision-making. While there is thus a large scope for diversity of definitions of what constitutes public interest and consequential actions, democracy requires that matters which are important for the good functioning of the state and matters which pertain to the exercise of public power for purposes of public interest are decided in parliamentary democratic procedures. And this is what brings us to artificial intelligence, because artificial intelligence is such an important issue, because it will be around and is already around like electricity, and it is such a powerful technology that the principle of essentiality, everything essential, must be decided in parliamentary process, means that democracy must take charge of rules for artificial intelligence. Because there is no democracy if democracy doesn't deal with the important matters relating essentially to power, to the exercise of power. And there's no doubt that artificial intelligence conveys huge power on those who develop it, those who use it, and therefore it must be dealt with in the democratic process. The concrete mix between plurality and democratically defined legal obligations expressing public interest varies from state to state and between policy areas. It is often at the core of the political debate. This balance, which Helen Alford at the beginning of our conference addressed, between individual self-interest, individual liberty on the one hand, and the common good, is often at the core of the political debate between those who want to shape societies through common rules and those who believe more in individual freedom as the way forward. And let me say something as a comment to Helen Alford's introduction. Maybe in contrast to her, I do believe that you will find allies in the political sphere. I do not believe that it is right to describe the situation in such a way that on the one hand you have those who are inspired by Thomas von Aquin who stand for the common good, and on the other hand you have politics only aiming for individual self-interest. I think politics today is on the contrary characterized by different directions, and you will find allies who may not be inspired by your religious and theological background, but who are willing to agree with you in terms of the actions to be taken. And that's what democracy is about. You do not need to agree on the reasons why you act together. The question is, can you agree on common actions? One can generalize that a free democratic society creates legal obligations but never aims for complete homogeneity as to the decisions on public interest, but it accepts divergences of views and actions on the one hand, while ensuring that, as to the actions of the state, there is democratic procedure and limitations, normally in the form of written constitutions or judge-made fundamental rights, which protect against actions of the state, and the legislator, the executive, and the judiciary are all measured by constitutional judiciary, which is itself bound by such constitutional settlement. This is important when the state uses artificial intelligence to exercise power over people. You know, China, the social scoring and surveillance technologies. This is where these checks and balances in terms of fundamental rights protections against the exercise of state power over your freedoms becomes very, very important. Furthermore, actions of the state are scrutinized in free societies by science and the free press. The latter is often called the fourth power of the state. Both should be free and with guaranteed independence, guaranteed by law, from power, private power and public power, so that they can provide a function essential to the good functioning of democracy and the common good, seeking and telling truth, without deference to or fear of power. Whether democracy and the rule of law as such are just procedural tools, or whether they are values and fit maybe also into your system of virtue ethics, may be a discussion within philosophy and theology, but it is not a discussion in law. In EU law, in the European treaties, it's quite clear. Article 2 of the Treaty of the European Union, I quote it now, for those who doubt that democracy is our highest value in Europe, and I speak here as an ex-official of the European Commission, as a European, I quote, "The Union is founded on the values of respect of human dignity, freedom, democracy, equality, the rule of law, and respect for human rights," end of quote. So, democracy and the rule of law is our highest law. These are legal principles. But according to our constitutional settlement, they are also the highest values. And my proposition to you would be in relation to AI, at least in Europe. We don't need to reinvent values because we have agreed on values. If you read the treaty, and I'm now not quoting the full Article 2, there are some more values like non-discrimination and so on, they are all there. And that makes arguments based on values, especially when you need to find majorities, and that's what you need in democracy, much easier. But these values, which I trust we all share, in particular those of democracy and the rule of law, are under attack today. They are squeezed in the pincer movement between absolutistic politics, a la Putin and Xi Jinping on the one hand, and increasing authoritarianism in many other countries, and on the other hand, the hubris of tech giants who market their products, and particularly now artificial intelligence, as a solution to all problems, claiming that neither democracy nor the law is necessary, and that these even constitute obstacles to attaining the common good. Now let's look back in history. Is this new? The interaction between technology and politics has a long history. Let me recall what Lenin declared in his report on the work of the Council of the People's Commission on 22 December 1920. I quote, "Communism is Soviet power plus the electrification of the whole country." Quote end. The hope that technology brings salvation is not new. And Lenin said more. And at that People's Congress, I quote again, "Henceforth, the stage at the All-Russian Congress will be mounted not only by politicians and administrators, but by engineers and agronomists. This marks the beginning of that very happy time when politics will recede into the background and when politics will be discussed less often and at shorter lengths, and engineers will do most of the talking." End of quote. The depolitization of politics, and now I look into the room. Unfortunately, the student who gave the presentation today in the working group on democracy is not there anymore because he also talked about this ambition. There he is! The depoliticization of politics through technocracy taking over has always been the dream of absolute power. And this dream was and is based on a simplistic view of the world, without plurality of lifestyles and opinions, and without the plurality of opinions on the way ahead, a dream in which eventually technology will solve all problems that human beings, humanity, and states are facing, combined with the claim that there is only one will of the people, and this will is represented by the incumbent regime. Chinese social scoring practices, forbidden in Europe under the AI Act, are but one expression of a dictatorship using technology to impose a homogeneous lifestyle and an expression of this view that there's only one will of the people. There is no space in this simple and absolutistic worldview for divergent views, no space for democratic deliberation, no space for plurality of faith. The self-empowerment of technology and absolutistic politics go hand in hand. They reinforce and support each other. Arbitrariness in this situation becomes the rule of the day, except for two certainties. One, and look around the world now. Those who rule and their friends benefit, everybody else suffers. Two, those who rule know no limits in doing what is necessary to stay in power. And if it's not them, their successors will be friends or family. They try to do away with the good old principle of democracy, that the way must be open for peaceful change. How did we get to this dramatic point in history? Increasing inequality of income and living conditions fuels discontent within Western countries, which is further fired up by the new communication environment of algorithmic control of opinion buildings, and I will not expand on this because Professor Gabor Ambros did this so eloquently. Neither the small size of the mobile phone screen nor the reduced attention span from tweet infection make it easy to sell reasonably differentiated policy concepts to people. This is one of the negative impacts not only of AI, but AI combined with these other elements of the new digital world. The winners of this new communication environment are simple but devastatingly stupid policies, demagogy, hate and violence, all appealing to the uncivilized instincts rather than educated brain. The shift away from democracy and towards strong-arm dictator-style politics, whether of the extreme right or left wing, is a global phenomenon. It is thus unlikely that there are not some common factors worldwide which fuel the new discontent voting behavior. Down-talking the law, inspired by merging neoliberal and tech-libertarian ideologies and a history of under-regulating the internet and social networks, allowing technological path dependency to develop, thus a lack of foresight and precaution. Remember Hans Jonas, the philosopher of religion, in his book 1979, The Principle of Responsibility, the inventor of the principle of precaution. We have a lack of precaution and foresight in tech policy are common underlying causes for the crisis of law and democracy worldwide. It is not possible to discuss the impact of technology or the decisions on technology without understanding the power politics around technology. Let us dwell for a moment on above-mentioned points. Let's consider for a moment the down-talking of the law. We simply forgot that the law is the most noble speaking act of democracy. We forgot that the making of democratic law is an opportunity for inclusive deliberation, the type of deliberation that keeps people and society together rather than dividing it. We presented the law as an obstacle to innovation, as a cost factor for business to be done away with, as a dysfunctional interference into individual freedom. But we forgot that the absence of the rule of law means anarchy and rule by raw power, and that's where we have arrived now. We also forgot that lawmaking is the moment of coming together around compromises, since lawmaking requires agreement of a majority. We allowed the willingness and ability to agree, whether on domestic laws or in international relations, to become the scarcest resource in the world. We gave our power over to arbitrary rule, and the result is that globally, in terms of the number of countries being a democracy or heading away from democracy, we have reached the low point of the century. And we see the same in markets. The biggest supporters of US President Trump are those who say competition is for stupids. We want monopoly power. We have an engineering elite which believes that there are only that the principle that there are only machines which work and those which don't work, and that there's only one good solution for societal problems is what has to be transferred to democracy, thus undermining the legitimate plurality of views in democracy. We need to relearn and teach the following generation that engineering follows the rules of math and physics, while society follows human-made rules of self-government and wisdom. These are two spheres within the same world which need to communicate with each other, but with both need to respect that their rules of functioning are not the same. The global dominance of very few tech corporations with a track record of breaking the law, whether the law on competition, consumer protection, data protection, intellectual property rights, in AI, you all know how they are stealing our works. Everybody who has published can check this. Your books have been used without you knowing it and without you receiving anything for it for training AI. in taxation, not paying their taxes, and getting away with it, that's the worst, has damaged the rule of law and democracy. The ideology of disruptive innovation and technology, with beer table sentences like let's move fast and break things, or let's just do it and call the lawyers to clean up afterwards, Eric Schmidt, head of Google, has devastating effects when applied to the law. Tech hubris has led to the attitude that law is optional and that breaking it is okay. The result of Europe's policy under a rather neoliberal conservative leadership is that Europe for long has been the continent with the highest market share of Google search in the world. And here I would like to mention a positive impact of AI and ChatGPT in particular. So Google was absolutely dominant, 95% market share in search for information in Europe. With the arrival of AI, AI becomes the new search. So the dominance of Google in searching information is challenged. Then we had ChatGPT as the app which is most downloaded in the world. And now ChatGPT, through innovation in China, DeepSeek is again challenged. So we cannot be against technological innovation where it helps us to free from monopoly dominance, where it provides new choices. And we believed a few years ago still that the position of Google in search is absolutely unchallenged, which was a huge problem for us. And this has turned out to be not the case anymore through technological innovation, namely with the arrival of AI. There is no doubt that only a combination of the law with all other measures in the toolbox of policy making can receive help to attain the common good. And this is exactly the line the EU is following. When I speak about the law, I refer to the rules which are adopted in formal democratic process and which thus carry the legitimacy of having gone through this process of representation and participation. So, legitimation by procedure is key. I'm not talking here about virtue ethics. I'm talking about pure Habermas legitimation by procedure. But the laws also carry legitimacy as to material content, as to their material content, as they serve values and objectives set out on the highest level of the law in our constitutions, which are giving us value orientation. This is at least what our jurisprudence says. The constitutions are not just, and the fundamental rights, are not just defense rights against the power of the state, they give us value orientation. And the laws, of course, have to be necessary and proportional for the purpose of actuating these values. The combination of both justifies that the state and its institutions enforce the rules against private parties, but also against emanations of the state with the power of the state. The law is necessary because in a world full of best intentions, even there, we have a need for coordination of behavior through binding rules. For example, very simple, whether we drive on the right or the left needs to be decided in a binding way. And the law also allocates risks and opportunities arising from new technology and new business models. Who shall carry the risk that an AI, in a manner unforeseeable to the producer, mutates through learning itself and does not do what it is supposed to do anymore, thus creating damage? Is this risk going to be carried by society as a whole, thus freeing the developer from the cost of insurance and also from the cost of reducing investments, from the cost of investments into avoiding such occurrence? For example, investments in following the AI on the market and watching how it is evolving? Or should this risk be carried by the developer, thus increasing the budget which needs to be allocated to safe innovations rather than just to innovation increasing profits for the developer? This is the type of decision only the law can take, and that's why we need the law. But make no mistake, in the European Union we have many laws which don't mention the word AI but probably have a higher effect on AI than the new AI Act. And Helen asked me a little bit to describe how these laws come about in the democratic process, and I want to do it in a very short way. The first question is always, which problem do we have to solve? What's the problem we want to address? And this problem definition must be clear. And then the second question is, who wants us to address this problem and who wants the solution which we are proposing? So that's the stakeholder views. With this methodology, we have put in place in 2016 the General Data Protection Regulation. It protects informational self-determination of people through pretty hard law, which is completely applicable to all artificial intelligence which processes personal data. Personal data being data which identifies a person or makes it possible to identify a person. Because of the pretty elaborate enforcement framework of the General Data Protection Regulation, I would say it is much more relevant to AI right now than the AI Act itself. Then, in 2022, we put in place the Digital Services Act. Again, absolutely relevant to AI as far as AI runs social networks and marketplaces. The problem the DSA, Digital Service Act, was supposed to address is twofold. First, the behavior of platforms as markets which self-preference their own products. When you search on Amazon, their own products come up. But second, the problem that platforms become a breeding ground for either illegal content or content which may be legal, but which in cumulation undermines democracy and fundamental rights. Example, continuous fake news, propaganda and lying. All of this is not illegal. It's not illegal to lie. But if you have websites which are used in Europe by more than 45 million people, full of lies, democracy doesn't function anymore. So the DSA, the Digital Service Act, obliges the big platforms to make sure that they don't become breeding grounds for content which in cumulation undermines democracy and fundamental rights and the rule of law. And then we have put in place the Digital Markets Act, which is a law to strengthen our instruments in competition law. Problem in competition law, where America has a great history, including of taking apart big corporations. If you think of the AT&T decision, where the big telephone company in America was split up into a number of smaller companies called baby bells, is that it always comes only after a dominant position or monopoly is there and the power of the monopoly has been abused. And this doesn't work anymore in the digital economy. We needed to have an instrument which already helps us to intervene before the dominant position is there. Why? Because in the digital economy it has become normality that the big players buy up competing startups or buy up startups which fit nicely as an add-on to their own business model and thus foreclose competition and choice in the market. Many of these elements of law are very difficult to enforce, and this remains an important challenge. And Sarah Spiekermann, in her presentation this morning, gave you an insight how, for example, the concretization of the AI Act is difficult, because when the parliaments regulate, and this is also the case in the AI Act, they regulate what is essential, the basic principles, but they cannot write the handbooks of implementation. This handbook writing is then left, as Sarah has outlined in the morning, to standard-setting bodies, and indeed, these standard-setting bodies are places of lobbying, like parliaments are places of lobbying. But what I would like to add to the presentation of this morning is that, of course, in the Commission and in the European Parliament, this problem is known. And that's why the AI Act, as well as other acts where we delegate detailed implementation rules to standard setting bodies, always contain a standard clause which says, first, if you can't agree, the Commission will do the rules. So it's a pretty clear indication. No, if there's lobbying going on all the time and there's no consensus, then we do the rules. But second, even if you agree, the rules must come back to the Commission and we check whether these rules are in line with the law. Because of course it's not the idea, neither of the European Commission nor of the European Parliament, that the standard setting body is used to undermine the higher law. There is a hierarchy of laws here, starting with the Constitution, then comes the law made by the Parliament in the normal legislative process, and the standards are on a lower level. They have to comply with the higher law. Now, of course, nothing here is perfect. Neither is the law itself perfect, because it is subject of a democratic compromise, nor is the process of the implementation of the law perfect. Does this mean that all this law is bad? Do we have to follow the battle cry of the lobbyists from Silicon Valley, which says we want either a good law or no law, by which they really mean we don't want any law? Of course not. To the lawmaking process, the same applies as generally to democracy. As Churchill said, it may be a bad form of government, but we have nothing better. Let me come to a close. AI is often compared to atomic power. It is also often compared to electricity. But even for electricity installations in your house, you need the installation to be certified by a control body, a third party, as you may cause fire also for your neighbor when you have an electricity installation which is not controlled. It is astonishing, to say the least, if not reckless, that the AI industry has driven legislators to accept that their AI products, which are now as broadly present in our life as electricity, and are certainly as risky as electricity, if not like atomic power, like Bill Gates says, or Elon Musk, they both say AI is like atomic power, they can be put into operation out there without any ex-ante check by a third party. It's all about self-certification. Having put AI regulation in place, however, in the democratic process is an important signal of a change of mindset in the EU. This is so because the initial intention of the Commission was to leave everything regarding AI to ethics. We had a high-level group on AI of experts which closed its work in July 2020, and the chairperson of this group, a captain of industry, went around, gave interviews and said, we don't need law on AI. It can all be done by ethics. And this laissez-faire attitude prevails until today in many quarters, as one can see, for example, in the recent high-level report of the United Nations on artificial intelligence with the title Governing for Humanity, Governing AI for Humanity, adopted in 19th of September 2024 by consensus. The members of this body could not agree on recommending binding international law for AI, nor did they give a clear position on domestic law, because the body had among its members an important number of representatives of the industry, which is making huge profits from AI, and of course oppose binding rules. As long as UN bodies seek consensus with industry, we cannot expect progress towards international law on AI, as there will always be important parts of industries that oppose any step in this direction. In contrast to this, let me just recall, in the Commission we also had what is called a European Group on Ethics. It's a continuous group of ethics professors which always accompanies our work. And they, in their opinion of June 20, 2023, called for laws on AI. I mention this so explicitly because, of course there's a moral hazard, sorry to say this, among philosophers to always say we need ethics, law, we don't know. My first question to philosophers is always, okay, tell me, what issue on AI can I leave with good conscience to ethics, and on which issues on AI do I need binding rules which can be enforced with the power of the state? With the proposal of the Commission on the AI Act in 2021, the Commission followed a promise by the new President von der Leyen at the time, and to present a regulation on AI. This act is not intended as an act to protect fundamental rights. It's a pure safety act. It's a classic act of product safety, and we will have to see how well it is enforced and how much difference it makes in the future. No rights are guaranteed for individuals under this act. So in contrast to, for example, data protection, individuals cannot go to the court and ask the court or a public authority to enforce this act. Lawrence Lessig, the great constitutional law professor of Harvard Law School, once said that it is 200 engineers who decide how we live. That was a caricature about, but with an important truth in it. We cannot leave key decisions of how we want to live to the tech industry or the technical intelligentsia alone. We must then invite them and re-win them to join the democratic debate, to bring their knowledge to the table and tell the truth about technology and business models so that democracy can take the right decisions on questions essential to fundamental rights and of great importance to the good functioning, to the public good of states and communities. These questions cannot be left either to individual choices of ethics nor self-regulation, but they have an important role to play in democracy when our society becomes technologized. There is no doubt that a large majority of individual engineers understand this and that they are ready to take responsibility, even political responsibility, for their innovations. Humans are not just failing information processors, law is not just mathematics, and justice cannot be delivered by algorithm. Democracy and a society cannot function according to the rules of engineering nor according to the rules of technological innovation, like the idea of the minimal viable option. You cannot have the law being updated like the programs of your mobile phone every 4 weeks. So there is and must be innovation in democracy, and it is one of the great fallacies of our times to think that innovation is only something technological, or even in the first place technological. The great innovations of our times, such as the separation of church and the state, the fall of the Iron Curtain, the creation of the United Nations, the agreement on the Sustainable Development Goals of the United Nations, also the creation of the European Union, all this are innovations which are not of technological nature. Many of these innovations were driven forward by people who were also people of faith. This is the great legacy you carry forward, a legacy of shaping society, securing peace, prosperity, and social justice and sustainability through democracy and law, built on faith and rules of reason. Do not abdicate to technology, but renew this legacy with pride. Help to win back the primacy of democracy and the rule of law over technology and business models in the age of artificial intelligence. Thank you very much.
Thank you. Adesso è la professoressa Margherita Daverio, insegnante presso la facoltà di Scienze Sociali, che fa la risposta. L'anno scorso era venuto di lui a fare quasi la stessa cosa, rispondendo l'uno all'altro sul diritto naturale.
So thank you very much. Thank you for the lecture. I try to speak in English and also to be short, so to leave more space I appreciate that I want to underline that you share with us in this part also the light and shadows of law. Maybe in your account, law is more the side of rights, and the relation with politics is, and the relation with politics is more generating shadows in your role. But I wanted to underline some big points. First is regarding the results on the function of law. So I would say the basic language, the directive function of law, the relation which is the relation between law and civil society, so also the common good. And this is important also as you showed in the trinity of democracy, fundamental rights, and the rule of law. This, I think, is very vital for democracy, not separating these concepts, otherwise democracy makes only sort of empty shell. Because, of course, in democracy, also the government of the majority and the democratic decision-making discussion is not the end of democracy in itself, but the end is shaping society and also keeping protecting the fundamental rights and also protecting the common good for the concept of legal and political system, the existence, the social and peaceful existence within society. And we wanted the Article 2 of the EU Treaty, and also, of course, this is the result from even before, also in the Constitutional Charter. I'd like to mention also the Article 2 of the Italian Constitution, where there is clearly the link between personalism and pluralism inside and solidarity. So this is very fundamental and valid. But also, of course, it's challenged by AI technologies. Then I will return in a moment to this. So this was the first part. The second one is to reflect together, as you often to us for reflection, how the situation in Europe regarding laws and treaty and banning rules. So I perfectly agree with the necessity of banning rules, especially in general. But of course, we cannot, for society, I think that rules are not the only element of the law. It's not the only the dimension of law, but they are important and fundamental for society. But also, I think that in the case of Europe laws, and especially regarding AI, as you mentioned, we can see a very interesting methodological process of relationship of correlation between the ethical reflection and the banning rules. So, of course, you underlined that also from 2000 this is an aspect also we discussed this morning in the break, that one challenge from the AI side to democracy is the fact that AI technologies encompass a sort of power that is the feature of technology, so how technology is, but then it puts in the hand of big companies the power which has not the features, the intrinsic features of political power, however limited. Because in political power, also because in the context of democracy, you can ask for responsibility and accountability. So we speak rightly of political power, not only of power itself. So I think that in particular for democracy and AI technology raise this challenge. And finally, so one comment also regarding also the issue discussed this morning regarding value design technology. I think what are the democratic values that are relevant for the design of technology, which are sensitive and also promoting democratic values. So, thank you.
Okay, thank you very much for your comments. I think you have a few important points. On the last one, the ability to influence public opinion through AI, the empirics are clear. More than 50% of people in the US and most of Europe now build their political opinion on the internet. This is a very crucial point because the platforms and the companies behind it are not subject neither to the legal obligations nor to the ethics of journalism. They don't have the orientation towards truth, for example, which classical journalism has. The journalist has, in some countries, legal, in some countries, ethical obligations, and regulatory obligation to check three sources, for example. Yeah. And I would say yes, that is a huge problem. My view is that we should subject the platforms as far as these obligations are concerned. For example, also the obligation to moderate, we should subject them to the same rules as the press, because the present situation means the journalistic press has to carry 10% higher costs for internet presence than the platforms. To make this concrete, if you are a newspaper, if you are a TV station, radio, you always have to have a number of editors on duty if you allow third-party comments on your website. Because as a press media, you have the obligation to make sure that all the third-party comments are not just only non-detailed, but they are not lies. The platforms don't have such obligation. 10% cost advantage, I would say, democracy cannot just stand by and let this happen. The rights for machines or human rights for AI, there are two areas here which we have to treat in parallel. I am of the strict opinion, like the US Copyright Office, no copyrights, no intellectual copyrights for works created by AI. It's human genius to be created, to be protected through intellectual property rights, not machine creations. And the second is no freedom of speech for AI. Human aggressive speech is protected. We are free to be very aggressive with each other and to lie. But the machines, in doing this in an automated way, should not benefit from this right. This is my view. These are human rights, as the word says, not machine rights. The relations of ethics to law, very related subject. I think there are two schools here. One is the good-willing school. Those are the people who say, well, let's talk about ethics when we are not able to agree on laws. The good-willing people, the American universities and in American companies, when they see cynical, dirty school of ethics, and those who work in ethics. And to take it very seriously, I take it too, very seriously, you have to be careful not to be abused by the second school. To be used as a pretext to avoid laws. We don't need law, we have ethics. And finally, on the interaction and the very important trinity, where I totally agree with you, we need to maintain. Why do we need to maintain it? Democracy, fundamental rights protection, the rule of law always go hand in hand in relation to not only technology, but everything. We have had rule of law countries before without democracy. Prussia. Do we want to go back to Prussia? No. We have regimes, autocratic regimes, which rely on popular democracy to quash any type of opposition or minorities. The purpose of fundamental rights protection is to rebalance the sometimes arbitrary democracy with the protection of individuals and groups. And to make it short, we need less Rousseau, more Montesquieu. I totally believe we need to invest in our representative democracy because it is a democracy of compromise which protects majorities. The Rousseau type of ideas about democracy leads to tyranny. And so, related to all those who, for example, say, oh, AI is great and social networks are great because they allow everybody to directly participate in the decision-making process. That is a terrible future. I do think we need the intermediaries of the representatives who are able to negotiate and compromise and who are willing and able to protect minorities and plurality, because otherwise we end up through technology in a tyranny situation as we saw around the French Revolution. So thank you very much.
Thank you for the quality of the conversation. Now, if somebody can ask something, yes? Yeah. How many times? Yeah, 5 minutes or that? Sister, 10 minutes.
You were closing the morning about tyranny was really appropriate to my question because I was thinking about what you were saying earlier about the depoliticization politics and the dangers associated with that. I think you said outsourcing the regulatory process to the standards to the corporation. How do we ensure that the democratic legitimacy of the regulatory process itself? Because this is in the United States, it's a long time before artificial intelligence was a mainstream concern. People are very concerned about when the state legislates in these highly technical areas, more and more effective legislative authority gets delegated to regulatory bodies that are more removed from the political process. So, what do you do to ensure that this state apparatus doesn't become the kind of tyrant that it is you're warning about?
Yes, so this question of democratic control is both related to the state apparatus, but also, and even more urgently, posed towards the standard setting bodies which are self-regulated, because they are not part of the state. And there is no easy recipe for this. In a modern differentiated society, it is clear we need processes of very detailed specification of rules of technology. That's unavoidable. And the problem of dealing with complexity in democracy is, I would say, unsolved. The mechanism which we have in Europe, as I tried to explain, is this. The Commission can delegate the specification of rules which are made by the Parliament to standards and bodies. So the idea is the Parliament makes the basic rules, and by the way, which are not meaningless. If the law says in a very simple way, AI must be robust. This is a lot. This can be and will be determined by the courts. It's not what does the courts mean. No. We can, as lawyers, we can come to conclusions what it was mean. But for the engineer, this is then specified in the standard making bodies. And as I said, the mechanism is always the same. If the standard making process is able to agree, what they have agreed comes back to the Commission. It is the duty of the European Commission to check whether the standard is in line with the parliamentary law. If they can't agree, it is the Commission which sets the standard through implementing rules. Both takes place under the control of the legislator and eventually of the courts. Is this control perfect? No. Can it ever be perfect? Can this problem be solved to perfection? No. But I would say we have checks and balances in the legal process, which helps to make sure that the lower rulemaking does not deviate from the higher level rules. This applies both in relation of the law to the Constitution and in the relation of the standard to the law.
Last one.
So one of the difficulties sometimes we have in the law is like technology, especially, is that technology, especially now, is very fast moving, and lawmaking bodies aren't necessarily correct or not fast moving. We don't want it to be too fast moving in any case, but how can we have a regime, like family law, technology that is community law? Which, by the way, is the economic process.
Yes, the classic argument by the tech community, the law must move as fast as technology. My answer to this is, if you mean by that the law must be changed as often as the code on our mobile phone is changed, that's impossible. It is also hopefully not necessary, because code is written for the students. Who are the students? The students are computers. They cannot think by themselves. The law in countries is written in language, hopefully in open language, which can be reinterpreted as the technology moves forward by humans who can think themselves. So, one hope I have is that we find here with you who rely on the scriptures, on written texts of the Bible, and other texts of your great authors like Communitas, analyze in rehabilitating language before the code. Because it is wrong to claim that the code is a better instrument, it's more precise. No. The human language can be written in law in such a way, I call this technology neutral law, which allows, when the technology moves forward and new business models arise, to have the law reinterpreted by smart appliers of law, but also judges eventually, in such a way that it doesn't lose its meaning. So I give you a very simple example. In our regulation on data protection, we said personal data is data which identifies a person or makes it possible to identify a person. In concretizing this, technological process changes the meaning, because we suddenly discover, for example, that a human can also be identified through a breathing pattern. 30 years ago, we didn't know this. In this moment, the breathing pattern becomes personal
very much. It's my great duty just to try to sum up a little, to just take some few flashes from the day and then make some thanks and conclude our meeting. I would like to start a bit with one of the comments that, leading on from one of the comments that Paul just made about this distinction between the sort of modern world out there and what we're talking about in Thomism that I was suggesting. And there is a sense in which I think this has value. There's a sense in which, for instance, the two nice words that the journalist was using at the end of a student panel of the ego system against the ecosystem. You know, the ego based on me against the ecosystem based on the natural, sustainable system of which we are a part. I think there is a sense in which this has value. There is a sense in which we can make a contrast like that. There's a sense in which what Sarah was saying about the church providing standards, and that we should understand standards in a more instrumental sense by analogy to this. You know, creating an environment in which we can achieve real good using standards. And I think any talk that can get Star Wars and Lord of the Rings in at the same talk is doing pretty well, as hers did. I think also the discussion about universals and immaterial intellect as providing a limit to the development of AI is also very helpful to us. Helps us, I think, get the problem in proper perspective. And of course, then you had the breakout groups, and I wasn't able to participate in all of them. I just wanted to say that the group that was working on behavioral economics, that was actually involved in a live experiment, the results from that experiment will be put into a paper and will be published, so we can share the results with you. So you actually participated in some academic research today in being part of that experiment. And then in the afternoon, I think this idea of theology as giving the most pregnant answer to the question, how can AI contribute to the common good? So I think it's very, very profound. I think it picks up on the standards idea that we had earlier, that the church is setting these standards. And it makes me think about Tom Holland's dominion idea, that over the long term, you know, over the 2,000 years or longer if we include the Judaistic tradition, this gradual impact that these deep ideas have on society, just shifting where the society, what is considered the norm, what is considered the standard kind of thing. This is, I think, really important, and theology is the sort of crucial discipline for giving us the vehicle for talking about that. In Professor Sisson's talk, I thought it was very interesting, the human-centered AI, and this idea that we could have high human control with high automation. This sort of combination of the best of technology with really developing human capacities. It made me think about John Paul II's talk about this technology in Laborem Exicens, where he says, technology is man's ally, he says. And he even says it can perfect, such a strong word for somebody trained at this university, in the Thomist University. It can perfect the human person as well. He also says, of course, it can be almost man's enemy, he says. But it's interesting he puts almost, because there's something always basically good, something that's constructed to achieve some kind of goal. And then I think, of course, we ended with this very, I think where we should have ended, with this sense of different positions, of this sense of we find a better way forward by listening to the different positions. In that sense, that democracy is so important to us, and that we can find allies. And so I want to come back here. You know, I characterize these two different positions, but Paul is quite right. That's one way of looking at it. There's another way of saying these, if we want to say these different positions, they're in all sorts of different places. We can find allies all over the place. And we actually need to find allies to work on this in practice. So I think there was for me, a very kind of strong and beautiful integration of the talks that we heard today, helping us really get into this topic, AI and the common good, which I hope that especially our students will be able to take further as their lives unfold. All the talks will be put on the YouTube channel. We will make a publication about this. I also wanted to say that we're hoping to launch in 2026 a follow-up project, a more interactive project with other universities under the title The Future of the Humanities in the Age of AI. And so those are my kind of ending comments. Now I would like to turn to some thanks. Thanks to David Dry, who is sitting over here, to all the students, yes, who helped us run the day, Claire, Joseph, Nicholas, and Sophia. David especially has been working on the conference for months and deserves special thanks. Thank you very much. And then, of course, we have many thanks again to our speakers, to our respondents, to our breakout group leaders, our translators, still sitting up there, still working hard. To the caterers, to the tech support team, to the video team, Evelyn up here and Santiago, to the members of the Admission Advancement Office who helped with communications and the website, and I would say most of all to all the participants here today, because there is no conference without the participants. And you've made this conference a true experience of Communitas, of the common good of our university community coming together around a discussion about a topic of crucial importance for today. And I can't help thinking, as we've been sitting here, you know, the cardinals have been going into their conclave as we've been talking, and we're in Rome, we're a pontifical university. It's pretty important for us what's going on in the Sistine Chapel right now. So I thought it wouldn't be inappropriate for us at the end to say a prayer together, maybe to stand and say the Lord's Prayer together, or whatever prayer you would like to say. I would say the Our Father, to pray for us, to pray for them, together, or for the whole church in this special time. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Great. So now it only remains for me to invite you to enjoy the aperitivo in the Hemiciclo. Thank you very much.
We can also thank Sister Ellen for reading this.